Have you ever opened your mailbox and felt your heart sink? There it is, a thick envelope, a return address from a hospital or clinic. You already know what it is before you open it a medical bill. And the moment you see the number on the page, your mind starts racing. How could this cost so much? Why didn't my insurance cover it? How am I going to pay for this? If you're a senior, you know that sinking feeling all too well. Because these surprises aren't rare, they're happening more and more. But what if I told you something that could change the way you look at these bills forever? What if I told you that you might not be legally required to pay them? Yes, really. Many older adults are paying medical bills that they shouldn't. And today I want to walk you through 6 types of bills. You may not be responsible for bills that could be draining your savings unnecessarily. Stick with me until the end of this video because these tips could save you thousands of dollars, help you avoid legal traps, and give you peace of mind in the face of confusing and often misleading paperwork. But before we begin, I want to thank you for being here. If you find this video helpful, I'd truly appreciate it if you liked it. And if you haven't subscribed yet, now's a good time to do so. Turn on the bell so you won't miss any future videos. These videos are made to help you protect your money, your rights, and your future. And one small favor, leave a quick comment below. If you find the video helpful, type the number 1. If not, type 0 and tell me how I can improve. I read every comment and use your feedback to make better videos for you. Now let's get started with the first bill you might not have to pay. 1. Medical bills that shouldn't be yours. Have you ever received a medical bill and thought, this just doesn't make sense? Maybe it was a charge for a doctor you don't remember seeing, or a huge fee from a provider that wasn't even in your insurance network. Maybe you assumed, like most people do, that if a bill arrives, it's be your responsibility. But that's not always true. In fact, that assumption can cost you a lot of money you might not actually owe. Medical billing is a complicated system. It's filled with technical codes, confusing terms, and unfortunately, a lot of room for error. Seniors in particular are at risk of being overcharged, misled, or even targeted by dishonest practices. Let's look at one common situation. Imagine this. You're rushed to the hospital after a fall. You're scared in pain and not thinking about paperwork. After a night of tests and treatment, you're discharged and sent home. 2 weeks later, you get a bill in the mail. It's not from the hospital, it's from a specialist whose name you don't recognize. Thousands of dollars. What's worse, this doctor wasn't in your insurance network. This is what's known as a surprise medical bill. And in many countries, including the United States, that kind of billing is not only unfair, it's often illegal. In the United States, the No Surprises Act, which took effect in 2022, was created to stop exactly this kind of situation. It protects you from being charged extra when you receive emergency care from an out-of-network provider at an in-network facility. So if you go to a hospital that's covered by your insurance, but a specialist you never chose treats you and then sends you a separate bill, the law may be on your side. You may not have to pay that extra amount. And this isn't just in the United States. Similar protections exist in many countries. In Canada, most emergency care is covered by public health insurance. Private services must follow strict transparency rules before charging you. In the UK, the National Health Service typically covers hospital care, and private treatments require clear agreements about costs before anything is done. In Australia, Medicare and private insurance plans are also required to disclose fees ahead of time. So no matter where you live, the bottom line is this: just because you receive a bill doesn't mean you owe it. Let's talk about how you can protect yourself and fight back if you're ever in this position. Start by requesting an itemized bill. Don't settle for a summary. Ask the hospital or provider for a detailed list of every single charge. Look carefully. You might find errors, charges for treatments you didn't get, duplicate billing, or inflated prices. For example, someone might be billed for a full day in the ICU, even though they were only there for a few hours. That kind of mistake is more common than you think. Next, check the provider's network status. Was this doctor or lab actually in your insurance network? If not, did you agree to be treated by them? If you didn't choose them or didn't sign anything agreeing to extra costs, you may have the right to challenge the bill. If your insurance denies coverage, don't assume that's the end of the road. Insurance companies often deny claims for things like missing referrals, incorrect billing codes, claims submitted too late, procedures labeled not medically necessary. You can appeal these decisions, and many times people win those appeals. All you need is documentation, doctor's notes, test results, letters explaining why the treatment was necessary. With the right information, insurance companies may reverse their decision or lower the amount you owe. Another tip, know your legal protection. If your bill came from an emergency situation or from an out-of-network doctor at an in-network facility, you can use local laws like the No Surprises Act to dispute the charges. You can also contact a consumer protection agency or legal aid service for help. And here's something else many people don't know you can negotiate. That bill for $10,000, it could be reduced to $3,000 or less if you can prove errors, question unfair charges, or show financial hardship. Some hospitals have financial assistance programs. Others will work with you just to get partial payment. If you ever feel overwhelmed, consider reaching out to a medical billing advocate. These professionals can go over your bills, speak to the provider on your behalf, and help you file appeals. Many seniors have saved thousands of dollars this way. One final word of advice, always ask for documentation. Before you agree to any medical procedure, ask for the estimated cost in writing. Afterward, request copies of all consent forms and itemized charges. If a provider can't show that you agreed to something, they may not be able to legally demand payment. And most importantly, don't let fear or pressure push you into paying a bill you don't fully understand. You have rights, you have options, and you are not alone. In the next part of this video, we're going to talk about another surprising type of debt that many seniors are told they must pay, but legally they may not have to. But first, let me ask you this. Have you ever received a medical bill that just didn't feel right? Share your story in the comments. You might help someone else who's going through the same thing. In the last section, we talked about medical bills that look urgent, but legally might not be your responsibility. Now let's take a closer look at another common situation that catches many seniors off guard, being asked to pay off someone else's debt. It often begins with a phone call. You're still processing the loss of a loved one, maybe your spouse, your adult child, or a sibling. Then, out of nowhere, a debt collector reaches out. They sound firm, almost aggressive. They say your late relative had unpaid credit card bills, and now the responsibility has somehow fallen on you. Maybe they frame it as a moral obligation. Maybe they say something like, wouldn't your spouse have wanted you to settle this? Or, it's part of your household, so technically it's yours too. If you're grieving, confused, or simply trying to be kind, it's easy to feel cornered. But here's the truth. You need to remember you are not automatically responsible for someone else's debt, no matter how close you were to them. Let's look at a common example. Imagine your spouse passes away. Later, you receive calls about an outstanding credit card balance, one that was entirely in their name. You never signed anything. You never used the card. You weren't a joint account holder. And yet the collection agency insists it's now your responsibility. They might say things like, this debt is tied to your household, or this was part of your shared life. They may even try to make you feel guilty. But here's the legal reality: unless you co-signed for the account or were listed as a joint owner, you are not legally obligated to pay that debt. Being an authorized user on someone's credit card does not make you responsible for the balance. That role gives you permission to use the card, but it doesn't make you a co-owner of the debt. Unfortunately, many debt collectors exploit grief and confusion. Seniors, especially those dealing with the loss of a loved one, are more likely to misunderstand their obligations. And collectors know this. They may send letters addressed to the estate of name, but word them in a way that suggests you personally owe the money. It's misleading and in some cases borders on harassment. So how should a valid debt actually be handled? Through the deceased person's estate, meaning their assets, not yours. If the debt is real, it should be settled using their property savings or other estate funds, not out of your own pocket. Not from your retirement savings, and not from your Social Security checks. Here's how to protect yourself in these situations. First, always ask for written proof. Under laws like the Fair Debt Collection Practices Act, FDCPA, in the United States, collectors are required to send you a validation notice. And this should include important details: the name of the original creditor, the amount owed, and documentation that shows the person who died, not you, was responsible for the debt. If they cannot produce this proof, you have the right to dispute the debt and request that they stop contacting you. You're not required to just take their word for it. Second, know your legal role. If you're the executor of the estate, the person assigned to settle financial matters, you may need to use estate funds to pay valid debts. But even then, you are not responsible for using your personal money. If you're not the executor, you're not obligated to engage with the collectors at all. Third, avoid accidental liability. This is an area where good intentions can backfire. In some states or regions, if you make even a small payment towards someone else's debt or verbally agree to pay, it could be interpreted as accepting legal responsibility. That means what started as a kind gesture could lock you into a legal obligation. So don't make payments or promises unless you've consulted someone you trust. And finally, if you experience harassment or manipulation, report it. If a collector threatens you, misrepresents the facts, or contacts you repeatedly in a way that feels coercive, file a complaint with your country's Consumer Protection Agency. In the United States, that would be the Consumer Financial Protection Bureau. In the UK, Citizens Advice can help. In Australia, Consumer Affairs is the agency to contact. And these organizations exist to protect people just like you, especially in moments when you're most vulnerable. A common tactic collectors use is repetition. They'll call again and again, or they'll send vague letters that sound official, hoping you'll pay simply to end the stress. They may even say things like, "It's just a small amount," or "It's the right thing to do." But that's not how the law works. Let's take another real-world example. A senior woman received a letter about a $5,000 medical bill for her adult son who had recently passed away. The debt collector claimed she owed the money even though she had never co-signed or agreed to anything related to the treatment. She was emotionally overwhelmed and almost paid the bill, but instead she asked for written proof. The collector couldn't provide any. So she stopped responding and the calls eventually ended. That's how powerful knowledge can be. If you're still with me and learning from these insights, please let me know in the comments by typing the number 1. I appreciate your time and I hope this content is giving you confidence and clarity. Now let's move on to another common situation where seniors are often pressured to pay informal personal loans with no written contract. We just talked about how easily misunderstandings, especially without written agreements, can lead to unfair financial pressure. But there's another surprisingly common trap that many older adults face, and it often shows up in the most ordinary way: a bill in the mail. Let's talk about utility bills for services you never used. Gas, electricity, water, internet. These are the basics of daily life. But for seniors especially, those who have recently moved, shifted to assisted living, or spent time staying with family, these everyday necessities can suddenly turn into a financial nightmare. Why? Because sometimes you may receive a bill for a property you no longer live in, or for services that should have been disconnected long ago. Imagine this: you've moved out, given notice, and thought everything was settled. Then one day, a letter arrives, a utility company, claiming you owe hundreds of dollars. You're confused, you don't live there anymore. But the bill is real and the pressure to pay is immediate. In one case, a senior couple relocated from their longtime home to an assisted living facility. Before they left, they contacted the electric company and asked to disconnect service. Done right, not quite. Months later, a $700 bill appeared, charging them for electricity at the old address. The company called it a final adjustment, but something didn't sit right. After digging deeper, it turned out the meter hadn't been read properly. That $700 reflected the usage of the new tenants, not the couple. Sadly, this kind of error isn't rare. In fact, it's shockingly common. Why? Because some companies, landlords, or even new residents bet on the idea that seniors would rather pay up than deal with the stress of arguing. But here's the truth. You are not responsible for services you didn't use. And more importantly, you have every right to challenge those charges. So how do you protect yourself? First, always confirm service termination. When you move or cancel a utility, don't just make a phone call. Request written confirmation, including the exact date service ended and a record of the final meter reading. Store these documents somewhere safe. You'll need them if questions come up later. Second, if you receive a suspicious bill, don't just glance at the total. Request detailed itemized records. Look for the service dates, the meter readings, and the specific usage. If the dates don't match your time at the property, or if service was already shut off, you don't owe it. Third, double check with your landlord or property manager, especially if you were renting. Sometimes landlords forget or avoid transferring the utilities to their own name. In some unfortunate cases, they may even try to shift their unpaid bills onto former tenants. Fourth, if you believe there's an error, dispute the bill in writing. Send the utility company documentation like your move-out notice, termination letter, or lease end date. Most companies are required to investigate, and many countries have strong consumer protection laws to support you. In the US, agencies like the Federal Trade Commission FTC can help. In the UK, there's Ofcom. And in Australia, you can turn to the energy regulator. And if the provider doesn't fix the issue, escalate it. File a complaint with your local consumer protection office, such as the Public Utility Commission in the US, or an ombudsman service in the UK. These organizations exist to hold utility providers accountable. Now, what if the bill has already been handed over to a collections agency? Don't panic. In the US, you have rights under the Fair Debt Collection Practices Act, FDCPA. Within 30 days of receiving notice, send the agency a written dispute letter requesting verification of the debt. Unless they can prove you actually used the service, they legally can't pursue payment. Here's a real-world example. A senior woman received a shocking $400 water bill for an apartment she hadn't lived in for over 6 months. She contacted the water company and asked for usage details. Turns out the landlord had failed to update the account, and the new tenant's usage was charged to her name, but she had her lease termination notice. With that document, she disputed the charges and the company canceled the bill. So remember, don't pay out of guilt. Don't stay silent to avoid conflict. You have legal rights and there are systems in place to protect you. Stand your ground and, if necessary, bring in the people whose job it is to make things right. If you're still here and finding this information helpful, I'd love to know. Drop a quick number 2 in the comments to let me know you're still with me. Now let's move to the next financial pitfall. You need to watch out for old debts that are legally unenforceable but still come back to haunt you. Sometimes what seems like just another call about a forgotten debt could actually be a trap. Let's continue from where we left off. Debt collectors might contact you about money they claim you owe, money tied to a debt so old it's no longer legally enforceable. But they're hoping you don't know that. They count on fear, confusion, and guilt to pressure you into paying something you no longer legally have to. And here's the real danger. If you take the wrong step, even by accident, you could unknowingly restart the statute of limitations. That would give the collector a brand new legal window to come after you. What kind of actions can reset the clock? Surprisingly simple ones. Making even a small payment, admitting the debt is yours, or signing a new agreement. In many states and countries, any of these actions could wipe the slate clean for the collector and restart the countdown all over again. That's why you must stay calm and cautious when dealing with these situations. Don't act on impulse. Don't act out of guilt. If you're contacted about a very old debt, the very first thing you should do is stop and verify. Before agreeing to anything, before sending money or saying a word about responsibility, find out the age of the debt. Know your legal standing. In the United States, the Fair Debt Collection Practices Act, FDCPA, gives you a clear path. You have the right to request a debt validation letter. This letter forces the collector to prove the debt is actually yours. It must include the name of the original creditor, the total amount claimed, and the date of your last activity related to that debt. Other countries have similar protections. In Australia, for example, the Australian Securities and Investments Commission, ASIC, requires collectors to substantiate their claims under strict guidelines. In the UK, the Consumer Credit Act gives consumers comparable rights to demand evidence before making any payment. And here's the empowering truth. If the collector can't provide valid proof, or if the debt has passed the statute of limitations, you have the right to walk away. Even if they keep calling or sending letters, they cannot take you to court to collect a time-barred debt. But beware, many debt collectors will still try to scare or guilt you into paying. They might call repeatedly, use harsh or threatening language, or try to make you feel irresponsible for refusing. This is especially harmful to older adults who were raised to always do the right thing and clear their names. That sense of honor, while admirable, can be exploited. So what's the key takeaway? Just because someone says you owe them money doesn't make it true. And in many cases, the law is actually on your side. Here's how to protect yourself. Keep records of every communication with the debt collector. Write down any dates related to the alleged debt. Never admit to owing the debt until you've confirmed its validity and age. And when in doubt, consult a consumer protection agency or legal advisor. You can also send a formal letter, preferably by certified mail, telling the collector that the debt is time-barred and demanding that they stop contacting you. Many consumer protection laws allow you to make this request legally binding. By learning about your rights and the rules surrounding old debts, you protect more than your money, you protect your peace of mind. And that's especially valuable for seniors who are often the targets of aggressive or unethical collection efforts. Now let's talk about something even more distressing. Fake bills from scammers pretending to be real companies. Perhaps one of the most heart-wrenching financial traps for older adults comes not from actual debt, but from fraudulent bills. These scams are crafted to look legitimate, so convincing they can fool even the most cautious person. Scammers often pose as debt collectors, utility companies, charities, tech support services, or even government agencies like the IRS or Medicare. They send out official-looking letters, emails, or calls demanding urgent payment for products or services you never requested or even received. These fake demands do more than hurt your wallet. They wear you down emotionally. They target your sense of duty and your desire to stay out of trouble. But here's the truth you need to hear loud and clear. You don't owe a cent on these fraudulent bills. Take the phantom bill scam, for example. You might get a letter or phone call claiming you owe money for antivirus software, a home repair, or a magazine subscription. Something that sounds familiar enough to seem possible, but that you never actually signed up for. The documents often include logos, fake account numbers, and even pieces of your personal info, like your name or address, to make the scam more believable. And then the pressure begins. You may get a follow-up call from someone claiming to be a billing specialist using urgent legal-sounding language. They might say things like, "If you don't pay today, we'll take you to court," or even, "You could be arrested." For example, a scammer might tell a senior they owe $500 for a renewed antivirus subscription, then demand that it be paid immediately using wire transfers or prepaid gift cards. So what's the golden rule here? Legitimate companies do not operate like this. A real creditor will always give you a clear, detailed invoice or written agreement. They will never demand urgent payment using untraceable methods like gift cards or wire transfers. Now, as we just talked about, not every bill you receive is legitimate. Some are flat out wrong. Others are the result of lazy mistakes. But there's a third category we need to talk about, the ones that are designed to trick you. And when it comes to scam bills, your best defense is knowing what to look for and how to respond. Let's walk through exactly what to do if you ever receive a suspicious bill. First and foremost, don't panic and don't pay right away. Some scammers rely on urgency, demanding fast payment through strange methods like wire transfers, gift cards, or cryptocurrency. These are major red flags. Once you send money that way, it's almost impossible to recover. So what do you do instead? You ask for verification. Politely but firmly contact the sender and request proof of the debt. That includes a written invoice or official documentation showing details like the original contract dates of service and the exact amount owed. If they can't provide that, stop right there. In the United States, you are protected under the Fair Debt Collection Practices Act, FDCPA. This law gives you the right to request written verification of any alleged debt within 30 days of the first contact. And it's not just the US. If you're in Australia, you're protected under the ASIC guidelines, and in the United Kingdom, the Consumer Credit Act gives you similar rights. Next, take a few moments to check if the company is even real. Don't assume a logo or official-sounding name means it's legitimate. Ask for the company's full name, address, phone number, and if possible, their business registration or license number. Once you have that, look them up through official channels. In the US, use the Better Business Bureau, BBB. In Australia, check the ASIC Business Register. In the UK, search the Companies House database. Still not sure? Type their name into a search engine with keywords like scam or fraud. You'd be surprised how many others have already reported the same trick. And here's a golden rule. Never share personal information with someone you don't fully trust. If a caller or sender asks for your social security number, bank account info, or credit card number before verifying their identity, hang up or delete the message. Many scam bills are just bait. The real goal is to steal your identity. Now let's talk about something even more powerful than facts your instincts. If something feels off, whether it's the rushed tone of the message, a strange payment method, or missing paperwork, listen to that inner voice. A real company will give you time details and proof. A scammer will try to rush you. So take a breath, ask questions, and don't let anyone force you into quick decisions. And if you're still unsure, report it. You're not alone, and the law is on your side. In the U.S., report fraud to the Federal Trade Commission, FTC, at reportfraud.ftc.gov, or contact the Consumer Financial Protection Bureau, CFPB. In Australia, go to scamwatch.gov.au or your state's Consumer Protection Agency. In the UK, report to Action Fraud at actionfraud.police.uk. And beyond just reporting, consider warning others. Share your story in community forums, local senior centers, or neighborhood groups. One voice can protect dozens more. Why are older adults such common targets for scams? Because criminals assume seniors are more likely to trust authority or to act out of fear of debt lawsuits or financial ruin. But you are not powerless. In fact, your life experience is a shield. When you stay skeptical, ask for proof, and know your rights, you become incredibly hard to deceive. And if you're ever in doubt, don't handle it alone. Reach out to someone you trust, a family member, a friend, or even a legal professional. A second opinion could save you time, stress, and money. Because here's the bottom line. No legitimate bill will ever require you to pay without proper verification. And there you have it. The 6 types of bills that struggling seniors are often mistakenly asked to pay, but legally they don't have to. I hope this video has opened your eyes to your rights and shown you how to protect your financial future. So here's my question for you. What's one thing you learned today that surprised you? Was it discovering you don't have to pay certain medical bills, realizing old debts might be expired, or spotting the signs of a scam before it hooks you? Drop a comment below and share what stood out to you. Your story might just help someone else watching today. And if you found this video helpful, please leave a comment. Give it a thumbs up and don't forget to subscribe to our channel. We've got more empowering tips ahead, all to help you live smarter, safer, and with more confidence.